Welcome everyone to today's panel on procedure and practice in the US of Colombia's International Arbitration Association. Thank you so much for joining us today, especially during this busy exam time, if you're a student or when you're a practitioner making time in the infamous not so quiet holiday season. Also, thanks to the Arbitration channel for hosting this event and providing the infrastructure. Our stellar speakers will focus today in particular on the enforcement of arbitral agreements and awards, as well as their annulment in commercial arbitration. And we will also have a look on investment arbitration. With this, I hand over to my colleague, Gustavo.
Thanks, Anya. Hi, everyone. My name is Gustavo, and it's a great pleasure for me to be with you today. I want to endorse my friend Anya's words and thank each and every panelist for being with us, for accepting our invitation. We know how hard it is to fit the agenda. And also, we would like to thank Arbitration Channel in the name of Lauro Parente for one more event in cooperation with DCIA. Even though our panelists, they do not need an introduction since they are all well-known and respected dispute resolution practitioners, I must register very briefly that today we will have the honor of listening to George Bermann, one of the most prominent arbitrators and our professor at Columbia Law School, to Julie Bédard, who is an international litigation and arbitration partner at Skadden, with a JD and LLM degrees at Columbia Law School, to Alice Franco, a litigation and arbitration partner at Ferro, Castro Neves, Daltro, and Gobide Advogados in Brazil. Alice has an LLM degree at Harvard Law School. To Luis Guerrero, partner at Lobo de Riso Advogados, also in Brazil. Luis has a master and a PhD degrees at the University of São Paulo and has also studied at Columbia Law School as a visiting scholar. And last but definitely not least, we will listen to Kabir Duggal, a senior international arbitration advisor at Arnold Porter and also our professor at Columbia Law School. He will be joining us today very, very soon. And without further delay, I give the floor to Julie, who will introduce an intricate topic under US law, which is the enforcement of arbitration agreement, particularly the hood sides question on arbitrability. Julie, the floor is yours.
Many thanks. And it's a pleasure to be here with all of you, and always a great honor to be in the same place, even if only virtually with George, and congratulations on putting the panel together. So today I think we may be discussing one of George's and my favorite topics, which is arbitrability and international arbitration. And that broadly stated, or at least simply stated, and devil hides in the details, is the question of whether the parties have submitted a particular dispute to arbitration. That really is a quote from the decision of the Supreme Court in Housen versus Dean Whitney Reynolds. The Supreme Court has recognized that the parties may agree to have arbitrators decide not only the merits of a dispute, but also gateway questions of arbitrability. And what are we talking about? And in particular, how do we contrast the way we think of arbitrability in the United States and the way many other countries, including Brazil, I believe, think of arbitrability? In many jurisdictions around the world, what you are talking about is whether the subject matter of the dispute is something that can be subject to arbitration as a matter of law, as opposed to deciding whether the parties meant to arbitrate or litigate a given dispute. And the former is the way I believe many, if not most, jurisdictions look at the concept of arbitrability, whereas the latter is the way we think of it in the United States. It's very focused on this notion of whether the parties intended a certain dispute to be subject to arbitration or whether it should be litigated. And then you also have the variation on the theme, of course, that when the parties have a contractual relationship, it's possible that they may have intended to litigate some disputes and arbitrated others. So many of these arbitrability disputes in the United States are about the interpretation of contracts, where you have to parse things out and separate the disputes between those that are subject to arbitration and those that may be litigated. We announced to you at the beginning of this program that the main question that we are considering is who gets to make that decision. What I've told you is simply just now is to explain the concept of arbitrability in the way we think of it in the US. I haven't told you who gets to decide this question, and that is a very thorny matter in the United States. In the US, courts have tended to keep a very active role in this determination. And here you're really butting heads with another very fundamental principle of international arbitration in so many jurisdictions, which is that of competence-competence, and a very well-known principle that I'm sure all of you already are familiar with, that addresses the notion that arbitrators have the ability, the jurisdiction to decide whether they have jurisdiction, which in many places around the world includes the question of arbitrability, of whether the parties intended to litigate or to arbitrate. In the US, we'll spend a little bit more time discussing this because the picture needs to be disentangled. There's many pieces to this. So first, let me begin in terms of what falls in the famously described questions of gateway issues as described by Professor George Bermann, which involve determining whether an arbitration agreement, one, was formed. That's one category. The second is whether the arbitration agreement is valid, second category. And third, whether the dispute falls within the scope of the arbitration agreement. And I'm literally quoting from the amicus brief of Professor Bermann in the case Henry Schein, and we'll talk about that in a few minutes. In the United States, there is a presumption that courts will decide these threshold questions, these gateway questions, unless the contract clearly states otherwise. So this is very fundamental. You do need the contract to change that presumption and indicate the party's intent. So as a matter of law, we don't jump to the conclusion of competence and that arbitrators have the jurisdiction to decide their own jurisdiction in the question of arbitrability. You really need the party's intent to be specific in this matter. And in First Options, a very famous US Supreme Court case, the court and all the members of the court agreed that the court should not assume that the parties agreed to arbitrate arbitrability. It's tricky, right? It gets complicated. The courts cannot assume that the parties agreed to arbitrate arbitrability unless, and this is a very famous quote, there is clear and unmistakable evidence that they did so. And if the parties can and want to do so, of course, they have the ability to specify their intent in their agreement. In the restatement, of course, I take a second here to acknowledge the leadership of Professor Bermann here, the amazing task that he has accomplished over, what is it at this point, probably maybe 10 years on the restatement. The restatement, of course, addresses this issue, and the restatement states that in order to make a clear and unmistakable agreement to delegate exclusively to arbitrators the authority to decide issues that the court would ordinarily entertain, the parties must manifest an intention to foreclose judicial consideration of these issues. That sounds easy enough, but in practice, it's proven to be rather difficult, and reasonable people have disagreed about where and when this intent, this clear and unmistakable evidence of the party's intent to arbitrate arbitrability does in fact exist. The upshot probably is that you might have parties who fully intended to submit all of their disputes to arbitration, but unfortunately, they end up in court, in litigation for years, debating these gateway issues. So I think it's important for perhaps all of us to pause here as a community, and I want to say particularly in the United States, that you have these two competing considerations of, on the one hand, if the parties did agree to arbitrate, they may be litigating for many years the question of arbitrability, which obviously defeats the intent to arbitrate. On the other, the proponents of making sure that parties are not forced or compelled to arbitrate without clear and unmistakable evidence that they intended to even submit the question of, to the arbitrators, let alone litigate on the merits. Those people would say the courts are the guardian of the party's intent, and as a result, it is acceptable for these matters to be litigated to their fullest extent. But I do think that when you take a step back, it is a very challenging proposition that we are facing in reality in the United States when we see the amount of time and judicial resources that is taken by the arbitrability questions. It might make sense for me now to perhaps take a look at one case in particular, and I'm sure we will be discussing this case among ourselves here on this panel, and it is the Schein case, in which the Supreme Court has been thinking about arbitrability. And I, as with many cases, or perhaps all cases, I always find it very important to make sure that we know what the underlying facts are, so that we really understand the legal issues that we're debating much better. And here, this is very simple. It starts with a controversy, really an antitrust lawsuit. And listen to the dates, 2012. This is when this all began. A lawsuit between a distributor of dental equipment and the supplier of the dental equipment. A distributor-supplier relationship. And the distributor sues the supplier, claiming that the supplier improperly restricted the distributor's sale in violation of US laws. What does the supplier do? The supplier moves to stay litigation and argues that the distributor was bound to arbitrate its disputes. And I apologize for all the things that are ringing here, because all of our devices, they seem to ring in multiple places these days, the beauty of technology. So the distributor is facing the situation. So you have the supplier moving to stay the litigation that was brought, and the supplier, as you will have guessed, is arguing that the distributor was bound to arbitrate the disputes. What did this clause look like? And I think it is important to focus on the words of the clause. The clause stated that any dispute arising under or related to the agreement, so far it sounds like many clauses you've seen. I'm going to skip the parenthetical. There's a big parenthetical here, shall be resolved. So you shall be resolved by binding arbitration. So you have the broad language, any dispute shall be arbitrated. The issue in that case pertains to the fact that there's a big parenthetical in the middle of the arbitration clause that says, except for actions seeking injunctive relief and disputes as related to trademark, trade secrets, or other intellectual property. And please focus on what you've just heard, which is except for actions seeking injunctive relief. And it does not say just preliminary injunctive relief, and potentially suggests that all forms of injunctive relief, including injunctive relief on the merits, could be swept by this language and could be subject to litigation if they are carved out by the language any dispute. Is that really what the parties meant, or they simply meant the usual, what we see, the usual setup of preliminary injunctive relief being available in the courts in aid of arbitration, which is the usual setup. But you see exactly now, having heard the language of this clause, the dilemma facing the parties and the courts, because the clause is far from clear in terms of describing the parties' intent, right? And then what else do we notice about that clause? It says nothing about who gets to decide the questions that I've just raised. It doesn't actually say the courts will be deciding whether a matter is arbitrable or whether the arbitrators will do so. However, the clause did incorporate and refer to the American arbitration rules, saying that the arbitration will be administered under those rules. And if you look at the rules, they, as many international arbitration rules, and domestic and international arbitration rules state, they have a provision saying that the arbitrator shall have the power to rule on his or her own jurisdiction, including any objections with respect to the existence, scope, or validity of the arbitration agreement, or to the arbitrability of any claim or counterclaim. So this is very specific language in the AAA rules, and it's known as something that is called incorporation by reference, the idea that the parties can have arbitrators decide questions of arbitrability simply by incorporating an instrument like the AAA rules, making that a part of their arbitration agreement. And then if you look at the rules themselves are specific and do say that the arbitrators and not the courts are meant to decide questions of arbitrability. The Supreme Court has not addressed this incorporation question in terms of deciding whether this language in the rules as incorporated in the clause is sufficient, clear, and unmistakable evidence of the party's intent to have the arbitrators decide questions of arbitrability. But many other courts have dwelled on this issue. 11 out of 12 federal circuits have found that the incorporation of these rules does provide the required clear and unmistakable evidence. So we do have a lot of cases, including in New York in the Second Circuit with the Contact decision. Now, in the specific circumstances of the Schein case, you may be still wondering what happened with that clause. It stated any dispute can be arbitrated except for the injunctive relief that may be sought by the parties. And so on the basis of a litigation that was commenced in 2012, 4 years later in 2016, the District Court for the Eastern District of Texas denied the supplier's motion to stay the litigation, finding that the arbitrability argument was wholly groundless. And in 2017, you're 5 years into the dispute between the parties, the U.S. Court of Appeals for the Fifth Circuit affirmed that decision. And I think what's important to bear in mind here is that the Fifth Circuit did exercise its own judgment regarding whether the dispute should be arbitrated. And because it thought it would be a stretch for the supplier to argue in favor of arbitration, they just didn't want to waste time having the arbitrators look at the issue. And this is exactly what allowed the supplier to get to the Supreme Court the Supreme Court granted certiorari in its January 2019 decision. At that point, you're 7 years into the dispute between the parties. I keep repeating this, and I think that will be the takeaway, perhaps from my own talk on all of this. I struggle with the notion that it takes that long to get these issues resolved. I'm finding that a problem with the system, an institutional issue that I think we need to resolve. And in that, in an opinion written by Justice Kavanaugh, and that was actually his first for the court. And the Supreme Court explained that where the party's contract delegates the arbitrability question to an arbitrator, a court may not override the contract by simply deciding that the theory of arbitrability was groundless. And that exception isn't found anywhere in U.S. law, so federal courts cannot invoke it. So the court, and I may conclude soon on this topic so that I don't take up too much time and others can chime in. The court affirmed the principle that parties may choose in their contract to delegate threshold questions of arbitrability to arbitrators. The courts must respect and uphold that choice and allow arbitrators to decide questions of arbitrability. But that decision expressed no view about whether that contract at issue that they were looking at, in fact, delegated the arbitrability question to the arbitrator, and that was remanded for the Fifth Circuit to decide the issue. The Fifth Circuit held that the courts don't need to defer to the arbitration tribunal on the question of whether the claims for injunctive relief were arbitrable. So you've now sort of come full circle, right? There was this big carve out in the clause. You go all the way to the Supreme Court. You come back down to the Fifth Circuit. The decision of the Fifth Circuit is the courts don't need to defer to the arbitration tribunal. The courts are empowered to decide the question of whether claims for injunctive relief that were in this carve out from the arbitration agreement, whether those are subject to litigation or litigation or arbitration. There's more that can be said. There's more questions that can be put to the Supreme Court. There's a lot more about this Schein case. But let me pause here and turn it over to my colleagues on this panel so we can continue our conversation about arbitrability.
Perfect, Julie. Thank you so much. This was very interesting. The US really seems to have a different approach, maybe not different, but rather a peculiar approach on arbitrability. And the duality of gateway and non-gateway issues, I guess, is something that for sure calls the attention and impresses some kind of sense, I think, foreign students. And this is my case and Anna's case. And so before we move on, I would ask the other panelists if they have any comments on Julie's presentation. Maybe Professor Bermann, I think he's willing to speak.
Well, Gustavo, let me say at the outset that Julie gave us a truly excellent presentation on the issues the case and cases like it raise. Probably in the interest of time, rather than pose a few questions to Julie at this point or comment, probably the best thing would be to say what I intend to say, Gustavo, and others on the panel may have specific questions for Julie, and they should certainly pose them now. But the best way for me to respond is simply to say what I'm prepared to say today as a panelist.
Perfect, Professor. So, Alice, Luis, any comments?
I have one question to Julie. Hello, Julie. Good to see you. I may say that you are following the situation about competence here in Brazil, the change in the Superior Court here about the interpretation of that institute, of that principle. How would you compare that situation from Brazil with no tradition about a prima facie approach, and now that open prima facie approach on the Superior Court? And in the US, how can we compare it?
So I would not dare purport to know the details of the case law in Brazil, and I will fully expect all of you to chime in on this. That being said, it has been my impression, right or wrong, and Luis, you can correct me, Alici, and others. It has been my impression that Brazil, by comparison with the U.S., or that the U.S. courts, by comparison with Brazil courts, in the U.S. we continue to be, I would say, a little bit more protective of the jurisdiction of the courts to avoid sending parties to arbitration in circumstances where they may not have intended to do so. And in practice, what this means is that competence is a bit weaker in the US by comparison to other jurisdictions in terms of default instincts of the judiciary. However, and this is very significant, I think we do eventually get to the right place with some of the incorporation by reference and the very clear statement in the rules that do recognize competence. But I think what you are seeing is that, one, reasonable people can disagree about that, and it very much depends. The way you look at all of this very much depends on whether you are a corporation that believes the arbitration agreement should be upheld, or to the contrary, that it doesn't exist as to the specific disputes. And to be clear, corporations that believe that they should not be arbitrating anything don't understand competence at all. Why would that make sense? If there is no arbitration, there's no dispute to be arbitrated. And conversely, a party that is facing what it perceives to be abusive challenges to the existence of the arbitration agreement can't understand what they're stuck litigating this for years in the courts. And I think we have fundamental philosophical questions. And if you look at it, we are, as a community, a bit stuck because we have to choose a place where these issues are going to get resolved. And depending on whether you err on the side of having the arbitrators decide them or the courts, you just resolve that philosophical debate differently in favor either of the proponents of arbitration or in favor of protecting the jurisdiction of the courts to avoid sending people to arbitration if they haven't intended to do so. But somehow, this has to be resolved. And I think by comparison in the US with most jurisdictions, probably also including Brazil, but I look forward for all of you to chime in, I think we're still more cautious. And competence isn't like the answer, the beginning and the end of all of this at all. It's a very nuanced, sophisticated analysis.
Yeah, I think that Brazil is going closer to the US now. I think in the beginning, the principle competence was really strong. Even that if a party started a litigation, the judge will simply say that, look, I don't want to even listen to the other party if they agree to take from the arbitration to litigation, because once there is this clause, you have to go first to arbitration. And nowadays, I think that we are living a certain crisis in Brazil, and the courts are really more cautious and are really willing to take the first step and decide before the arbitral tribunal. So we are in this moment that we are also looking for common grounds, or at least the middle way pathway to find where we want to be, because we went from one extreme to another. And I think the courts are not very they're too strong against arbitration right now, and it's not also the best way to go.
Okay, thank you so much. Are there any other comments from the speakers? Okay, fine. Yeah, it was really interesting to get also a perspective of how this is tackled in Latin America. So then I will hand over to Professor Bermann to give us some insights also on recent developments.
Well, thank you. Thank you, Anja, and thank you to all the organizers, and thank you to Julie for really presenting so skillfully what is at stake here. Just before I comment specifically on the issue Julie raised, I think a couple of background observations are helpful. I'm sure everybody who's listening today understands this, but many don't, that the system that Julie described is not an entirely binary one, by which I mean it's not that the issue of arbitrability is either for the court or for the tribunal. It's a little more complicated than that. I think Julie will agree with me that there is no doubt that gateway issues, even gateway issues, may be decided by the tribunal. The tribunal can decide gateway issues, it can decide jurisdictional issues, admissibility issues, and of course, merits issues. So what's really at stake, and this was implicit in what Julie had to say, is whether, despite the fact that tribunals have authority to determine their own competence, parties nevertheless have the option of getting a judicial determination first. So it isn't entirely binary. Gateway issues are not reserved to courts. On the other hand, we might say non-gateway issues are reserved to arbitrators. I think Julie will agree with that. But I think it makes the whole inquiry a little more nuanced. We're not, the view that the courts have this opportunity is conditioned on their being asked to exercise it. And no party is required to put the arbitrability question before a court before putting it before the arbitrators. So I think that's very important to have in mind when we're confronting this issue. The second point, which I think is implicit in the question Alicia raised and Julie's answer, really is that, as Julie said, competence itself is subject to interpretation. It may sound a little simplistic, but it is generally understood that in some jurisdictions, and this may have been Brazil at one time, that competence not only empowered tribunals to determine their own jurisdiction, but also disempowered courts from doing so. And of course, the French call this competence has its positive and its negative dimension. Positive, it's authorizing tribunals. Negative, it's disempowering courts. That is unclear. It is wholly unclear that is the understanding of competence in the United States. And it's a very common view that we view competence as positive only, empowering, but not disempowering. And that's obviously a fundamental distinction. So I think that's critical sort of observations as background to what we're talking about. Now, moving to a much more general matter and a matter of greater principle, which is, of course, what Julie has mainly focused on, is, to put it very simply, and I'm paraphrasing Julie, really, but to put it very simply, to what extent are we going to privilege the efficacy of arbitration as compared to the legitimacy of arbitration? And legitimacy is a strong word. I don't really mean legitimacy. I mean the existence of consent to arbitrate. And I think, Julie, that's really what you were alluding to when you spoke about the dilemma that the system is facing. Obviously, we want both. We want to be sure that the parties aren't required to arbitrate a dispute they did not agree to arbitrate. And the reason for that is simple. The default in the United States, and I think it should be everywhere, is that your forum is a court. And you aren't deprived of access to a court on a dispute unless you agreed to arbitrate that dispute. And therefore, the principle of consent in some quarters, and I'll confess mine, is fundamental. At the same time, I fully acknowledge and appreciate the observation that that comes at a cost. That insistence on consent to arbitrate comes at the very cost that Julie identified. Because if we're going to allow the courts, I underscore, if asked to do so, and they don't have to be asked to do so, that promotes the principle of consent, and at the same time entails a very high likelihood that the case is going to remain in court for a substantial period of time before the arbitration gets underway. And I think Julie's right. In a way, it's almost philosophical. To which of these values, to which of these goods are we going to pay greater attention, or put more objectively, how are we going to reconcile them? I want to make one positive or constructive suggestion, and that is one way to mitigate the cost that Julie identified would be for us to do something we really haven't quite done, which would be to take every effort and make every effort for that judicial role to take as little time as possible. I don't quite know how that can be done, but I'm sure Julie would agree with me that it would be very constructive, and it would lighten or ease the dilemma if the amount of time and the amount of resources invested in this judicial determination were reduced without avoiding the issue at hand. I don't think we're thinking enough about that. I think there are ways to short circuit, if you will, what this cost consists of. Now, that having been said, and turning to the principal issue and its specifics, should we say competence notwithstanding, parties, if they so seek, are entitled to a judicial determination of arbitrability? Julie was more temperate than I am, as she always is. She reserved judgment, though I think I know where Julie's sympathies lie, but I'm less temperate. And so I would, in the interest of provoking debate, but also in the interest of expressing what I think, let me suggest why I think the federal courts are following the wrong approach. I would supplement something Julie said, which is, I think, remarkable, that even though 11 of 12 federal circuits have taken the view that the incorporation of AAA rules or UNCITRAL rules that contain a competence-competence clause constitutes clear and unmistakable evidence, the courts of the states in the United States are divided over that matter. And I don't want to dwell on this, but it may come to you all as a bit of a surprise that our state courts could continue to take a position on arbitrability and delegability after the federal courts have spoken so clearly and so practically uniformly. That's a matter for another day, but it is the reality. And as we speak, there's a case in the Supreme Court of Florida and a case in the Supreme Court of Texas, both of which are addressing this issue, and they feel they must, despite the fact that the federal courts have been so clear, because their own lower state courts continue to disagree. I think that underscores Julie's observation that reasonable people can disagree, because we have state courts that are taking a position that the federal courts have squarely rejected. And all of you may wonder, how is that possible when the Federal Arbitration Act is a federal statute? Gustavo, if we have any Q&A, we could go down that rabbit hole if you'd like, but that's a question of federalism in the United States. Now, returning to this question about the incorporation of rules, I think there are two things to bear in mind. First, as Julie said, in the first options case and in others, the Supreme Court has been, pardon the term, unmistakable. And I think it has been clear and unmistakable that clear and unmistakable evidence of a delegation is necessary. So there is a presumption in favor of courts having that authority, and the presumption is a very significant one, clear and unmistakable. That doesn't mean by the preponderance of the evidence. That means clear and unmistakable. So we have a powerful presumption. Because, as Julie said, every modern set of rules contains a competence-competence clause, and if that competence-competence clause, in and of itself, by itself, through incorporation by reference in an arbitration agreement, is enough to constitute clear and unmistakable evidence, then the presumption has, to put it mildly, been reversed. Competence-competence clauses are ubiquitous. It will be the rare case where it won't be found these days. It might be in the lex arbitri. It's in the UNCITRAL model law. It doesn't even have to be in the rules. So I think apart from how we feel about this, I think we have to recognize that the presumption created by first options is, by virtue of the federal court's positions, the courts of appeal, I think it's not an overstatement to say that the presumption is reversed, and powerfully reversed, quantitatively, if in no other way. So I think that's an important thing to take into account. Secondly, if competence empowers tribunals but doesn't disempower courts, if that's what competence means, then I don't think it matters that we find competence in the rules. The fact that competence appears in a set of rules does not entitle us to redefine it. And I think we would be redefining it. We would be adding a negative dimension to the positive dimension. And I think that is irreconcilable with the notion that this delegation is clear and unmistakable. The very ambiguity, and I don't even think it's ambiguity, but at the minimum, the very ambiguity about what competence-competence does to courts prevents me, at least, from finding clear and unmistakable intention to foreclose access to a court. So I genuinely believe that the federal courts are not getting this right. The arbitration bar, the international arbitration bar, unsurprisingly, in general, tilts in favor of allowing a competence-competence clause to become so decisive that it, by definition, satisfies clear and unmistakable evidence. And the great weight of support in the bar is in that direction. I say unsurprising because of the assumption that allowing competence-competence to have that effect on the first option's presumption is pro-arbitration. It's not a big surprise that the arbitration community, the international arbitration community, is pro-arbitration. And as Julie has heard me say before, and my students have heard me say before, I honestly and genuinely and sincerely think that it may be pro-arbitration for arbitration to hold on tenaciously to the principle of consent, and that it risks being short-sighted to act as though the more arbitrations we have and the faster we get to them is how we measure what it means to be pro-arbitration. Now, I'm speaking very personally about this. I've about used up my time, but Gustavo, if you would permit me to say a word about Beijing Shougang, or we can wait on that. But you prefer Gustavo?
No, Professor, Anya and I allow you for sure to speak on that.
Very short. Okay. So earlier this year, in the fall, the Second Circuit decided a case on a related matter that I think, and many of you know, I think, exacerbates the situation greatly. And without going into any detail, but there may be questions about it, in this case, Beijing Shougang v. Mongolia, Beijing Shougang brought an arbitration against Mongolia, and the tribunal decided that the dispute did not fall within the scope of the arbitration agreement. So it's not the usual case, it's the converse. The tribunal found that the dispute was not covered, and the investor, Beijing Shougang, wanted that reviewed. The situation, of course, was, since we're now post-award and we're in a court, what is the degree of deference owed to the tribunal's determination of this matter? It's a matter of degree of deference. And what the Second Circuit held, to be very direct about it, is that while the arbitration agreement did not incorporate any rules, it was an ad hoc arbitration, nevertheless, the parties' conduct constituted clear and unmistakable evidence of a delegation of arbitrability to the tribunal. And it based that assessment of the parties' conduct on the fact that Beijing Shougang agreed that the matter could be addressed by the tribunal. So Mongolia objects to jurisdiction. The dispute is outside the scope of the arbitration clause. And Beijing Shougang contests that objection before the arbitral tribunal. It's my contention that it had no choice but to do that. But what the Second Circuit held was that Beijing Shougang, having submitted or allowed the issue to be submitted to the arbitral tribunal, gave clear and unmistakable evidence that it was foregoing, abandoning, relinquishing its right to a de novo determination of a gateway issue. Now, once again, and in conclusion, Gustavo, in investor-state arbitration, it's been a long time since I've seen a case where there isn't a jurisdictional objection. I think you will agree with me, hardly a case. And so the claimant has no choice but to respond to the objection. And if responding to that objection constitutes clear and unmistakable evidence of a forfeiture of access to a court for an independent determination, then we have yet another factor that makes it virtually certain that there will be virtually always a delegation of arbitrability to the tribunal, thereby, in my opinion, eviscerating first options even more than the incorporation of institutional rules discussion has done so. I don't think it's an exaggeration now, if we're practical about the matter, is that delegation is everywhere. And just one last thing, Gustavo. A thought has occurred to me recently, whether we should be embracing delegation at all, for two reasons. First of all, in the Whole Street decision, the Supreme Court said parties do not have the authority to alter the grounds for vacatur of awards. But what does a delegation do? What does a delegation do? It alters the standards. And if it's a New York Convention case, does this mean that, contrary to our assumptions, that the grounds for denying enforcement of an award under the New York Convention are now not to be independently determined by a court, but are to be determined at most with deference to the arbitral tribunal? But those last two remarks of mine do not go to the question Julie was addressing. They actually go to what the impact of a delegation is. So, Gustavo, Anja, pardon me, but I hope I've put enough on the table to generate discussion.
Thank you so much. Thank you also for giving us this additional facet discussed in the Beijing Shougang case. So we actually have a question in the audience going down the rabbit hole of the different legislation in federal and state courts. So Luisa Canero is asking, regarding the roles of federal and state courts on deciding arbitrability and delegation, what would you say is the importance of preemption?
Yes, of course. It would seem, I would have thought, that the state courts were preempted from taking a position that the federal courts have so unanimously taken when it comes to the interpretation of the Federal Arbitration Act and the whole regime of enforcing agreements to arbitrate. Those of you who've studied preemption in arbitration know that it's a fairly strong doctrine. And while states can regulate international arbitration, they cannot do so in such a way as to undermine arbitration. Now, I think there is a short answer to your question, and it's one that has been brought to my attention by others. State courts are bound by the interpretation given to a federal statute by the United States Supreme Court. But perhaps to your surprise, they are not bound by the interpretation given to a federal statute by the lower federal courts. That will explain why Texas courts, Florida courts, and frankly, courts of other states have persisted in adopting the view that I favor, and they do not feel that they are bound. I'm not sure this is an issue quite of preemption. I would say it's more an issue of the supremacy of federal law over state law and the supremacy of federal interpretation of federal law over state interpretation of federal law. But whether we call it preemption or supremacy, the reality is that, to the surprise of many, the courts of our states, in some measure, are continuing to take a position that the federal courts have uniformly rejected. And it will not be, therefore, if I'm correct, until the United States Supreme Court does eventually address this question, that the state courts will lose their ability to go down a different road. I hope that at least explains why we have this continuing rebellion by some state courts against the prevailing federal view. I would say within a number of months, we'll have at least 2 state Supreme Court decisions. And maybe someday we'll have a US Supreme Court decision. And that will be definitive.
Okay. Are there any other from the speakers? I've seen also Kabir Duggal just joined us. Alice, Luis, Julie, Kabir, any comments to Professor Bermann's speech?
Luis, go ahead if you want to say something. I can comment after you. You're on mute.
I'm okay. Thank you, Julie. That's perfect for me.
So I was just going to bring another reality check for all of us to consider. I'm always big about reality checks. And it's the following, which is, as we see these issues on either side of either a corporation taking the position that there is no arbitration agreement versus the other taking obviously the opposite view, in addition to the timing consideration that we discussed earlier of these matters taking a very long time to be ultimately resolved, and I think the lack of resolution on a timely basis is an issue. The other is the strategic dilemma that faces a party that believes the arbitration agreement doesn't cover the dispute or doesn't exist, which is that you are really faced with a situation where, of course, your predisposition would be to engage the courts on this matter. But George was right that it's not exactly binary, because in a lot of situations, you will see parallel proceedings in that the arbitration tribunal will move forward, mostly motivated by the competence-competence principle. The arbitrators may or may not find that they are prevented from moving forward in their analysis because of the existence of parallel judicial proceedings. And it gets very complicated for a party that believes the arbitration agreement is not valid or doesn't cover the dispute at hand, because that party wants to meaningfully engage with the courts and at the same time is faced with a difficult decision of what to do with the arbitration tribunal. And I think this is not an insignificant matter because of the lack of clarity on this. Ultimately, a party faced with that situation has to decide whether it will distrust the arbitration tribunal on the back of saying this is a decision that the court should be making on arbitrability. But that's potentially a decision that comes with a high price. It's a decision that's internally coherent and consistent with taking the position that one should not be in arbitration, but it is one that in practice, in reality, could have difficult consequences for that corporation. So I guess this is another angle that I have found to be tricky about our whole arbitrability question, and it very much arises also from the lack of, or not necessarily the lack of clarity, but certainly the decent amount of controversy we have in this area. And this is absolutely not just a United States issue. I think we have, we face this in any number of jurisdictions. So maybe just to conclude where we began, this is one of the trickiest issues we're facing in international arbitration. Intellectually, conceptually, philosophically, this is not an easy one we're grappling with, and I don't expect us to be done with this anytime soon. Particularly, as George mentioned, when you see the complexity of the map and the geography in the United States and the many different views. That's the only thing I wanted to add at this juncture.
Gustavo, just a little PS on this. I think it's obvious to everybody, but let me dispel it out. Those who are resisting arbitration of a dispute on the ground that the arbitration agreement wasn't formed or was invalid or doesn't cover the dispute, or we didn't mention it, or that the party is a non-signatory, which is also a gateway issue. To that party, it makes a very big difference who is deciding the matter. Rightly or wrongly, that corporation that Julie is alluding to would much rather have this question decided by a court, which it assumes will be more conscientious about the consent question than the tribunal will be, and therefore there may be a different answer to the arbitrability question, depending on which is the forum that gets to decide it, if only one does. Not to mention something Julie did say, which is there's an element of illogic to having a tribunal that owes its existence and its authority to an arbitration agreement whose existence and validity is being challenged rather than a court. This corporation is going to say to itself, right, Julie? I never entered into an arbitration agreement or a valid one, or the dispute wasn't covered. Therefore, the tribunal, in my assessment, has no authority, much less the authority to determine whether it has authority. So it gets pretty interesting, but I think Julie will agree, it could be outcome determinative of the arbitrability question. Who gets to decide it? I don't know we have any data on this, Julie, but it's my instinct.
Okay, I'm afraid in the interest of time, we have to move on and leave this very interesting and much debated topic aside and come to our next speaker, who is Alice, and she will tell us more about the annulment of arbitral awards. Floor is yours.
Well, thank you. First of all, thank you for the invitation. It's an honor to be a part of this panel. I will talk a little bit more of the annulment, which is the interference of the courts after the award. So the arbitration is recognized as having many advantages over litigation, and such as technical expertise, speed, costs, informality, avoidance of national jurisdiction. In order to succeed in maintaining these advantages, the arbitration cannot have a full-scale review of the award. It's an important incentive for the parties that chose arbitration to have this impossibility to appeal from an award based on the merits. It does not mean, however, that the parties are completely unprotected against mistakes or violation of fundamental procedural rights. It's crucial to have a credible, efficient system to prevent abuses in the arbitral award that will eventually create uncertainties and in real life will result in courts being reluctant to enforce the awards. At the same time, it's important to remember that too much national jurisdiction, judicial review, will simply transfer back the decision power to the courts, killing probably the most important benefits of arbitration. So there must be a balance in the annulment lawsuit between an effective arbitral regime and the role of the judicial review. There are, according to New York Convention, there are two kinds of jurisdiction. And generally, the party that's unhappy with the outcome of the arbitration will probably seek for the annulment of the award before the competent court. The losing party, if the losing party fails to satisfy the award, the prevailing party must look for enforcement. As I said, these developments increase the interference of the courts in arbitration and consequently reduce the attractiveness of arbitration as the preferred means of dispute resolution. As you can see, there are two means of having this interference. One is the annulment, the other one is the enforcement. It's well accepted that international arbitral awards are subject to annulment solely in the courts of the seat of arbitration as a primary jurisdiction. All other jurisdictions will be defined as secondary jurisdiction, and who will be entitled to grant or deny enforcement, but not to vacate the award. It's true that the New York Convention suggests that the parties may also vest annulment authority to the courts of the law applicable to the arbitral proceedings. Objectively, the U.S. courts can annul arbitral awards rendered in the U.S. or foreign awards that selected U.S. law as the law applicable. In practice, however, the parties avoid complicating the matter and will often look at the national courts only for the seat. So only look for the primary jurisdiction wherever the seat of arbitration is. And then the effects of these. What are the effects of the annulment? The New York Convention authorized a court to deny recognition and enforcement of an award that has been set aside by the competent court. Naturally, an award that has been annulled by a jurisdiction becomes null and void and will not be enforced by that same jurisdiction. The question becomes relevant when a party is trying to enforce an award that has been void by another jurisdiction. There have been many different approaches to answer the same questions. In Germany, for instance, the annulment of an award by a competent court set aside means that, the annulment of the award will simply set aside the award universally. Thus, a court in Germany will not enforce the award if it was annulled by the seat of arbitration. So if the award was annulled, it simply cannot be enforced. France, on the other hand, established an opposite procedure, according to which the annulment of an award of the seat is not available ground for denying recognition or enforcement. Thus, a foreign court decision of the seat of arbitration setting aside the award will, as a rule, not prevent this award from being enforced. French law maintains that international arbitration constitutes its own international legal order, and the award does not belong to the seat. I must confess that there is an appealing ideal to have a completely free and a-national arbitration proceeding where no national jurisdiction will be able to void the award to all other jurisdictions. However, in practice, the winner of a defective award, even after the annulment, continued to go to other 145 jurisdictions in an effort to enforce the award, will simply harass the party and it will create instability in the arbitration practice. I believe experience shows that the difference between primary and secondary jurisdiction is an important and attractive characteristic of the arbitration. After all, we must remember that the parties initially agreed to choose a jurisdiction to avoid the potential bias of a particular national court, which might have preference to one of the parties. The French approach might keep an ever-present danger of this loser party to go and retreat to its own national courts and try to secure the annulment of the award. Thus, I believe that there is now a kind of an intermediate path, and the U.S. has taken apparently this path because the award can be set aside by the competent court, but it can be enforced elsewhere. But it's not. There is a strong presumption of denying recognition and enforcement, but under highly exceptional circumstances, the enforcement can be allowed. So I think there is this middle path that the U.S. now is adopting that seems to be a more secure path, because it is the middle way from both German and French. It's well founded that the New York Convention opted not to regulate the annulment process, leaving it to be governed by the law of each state. In the US, there is the Federal Arbitration Act that was enacted in 1925 to initially change this hostile response of the courts towards arbitration. According to U.S. law, the list of the list of the grounds of the annulment cannot be changed, and we should always remember that judicial review of an arbitration awards must always be extremely narrow. Even if there is a kind of indignation in reviewing the award, the court must resist the temptation not to simply answer and try to save the imperfection of the proceedings, and simply because the court must look for the arbitration decision and respect it. It's not, once again, it's not a decision on the merits. is merely a decision on the grounds of the list of a list of certain grounds that we're going to go in details that is listed in the U.S. law. So the first reason that we can annul is corruption, fraud, and undue means. It's important to understand that the fraud and the corruption and even the undue means, it's not sufficient to find it, but it must be also have the nexus between the alleged fraud, for instance, and the basis of the panel decision. For example, a panel that hears the allegation of fraud and rests its decision on different grounds, clearly independent from the fraud issues, this award cannot be annulled. So it's not sufficient to have fraud. The fraud must have eventually changed or have a nexus to the panel decision. The undue means, it's a more general concept than fraud and corruption, and it implies not only illegal and immoral means, but also those that are manifestly improper, such as the issuance of threats to an arbitration, or even attempts to improperly influence the outcome of the proceedings. But once again, it must influence the outcome of the proceeding. The second ground for annulment is the evident partiality or corruption in the arbitrators. Evident partiality can be difficult to define, and it's probably the need to be unbiased, but also to avoid even the appearance of being biased. It depends on whether an objective observer who is fully informed of arbitrators' conduct and relationships could doubt the arbitrator's independence and impartiality. In theory, such challenges could be largely avoided through timely disclosures. The third ground for annulment is the arbitrator if the arbitrator is guilty of misconduct. This ground is meant to assure the fundamental fairness of the proceeding and equality of arms, but cannot be invoked as a second guess of the tribunal's procedural rulings. Arbitrators is not bound to hear, for example, all evidence tendered by the parties. However, he must give the parties an adequate opportunity to present its evidence and arguments. An evidentiary error must be the one that simply affects the rights of the party and deprive the party of a fair process, in the sense that the panel failed to address all issues presented and finish up rendering a fundamentally unfair award. The fourth ground is when the arbitrator exceeds its power. We cannot forget the arbitration is a matter of contract. The power of an arbitrator is dependent on the provision under which the arbitrator is appointed. So if the arbitrator decides contrary or exceeds its provision, this arbitrator exceeds its power. It's important to notice that the Federal Arbitration Law does not expressly talk about non-arbitrability or public policy, but you can interpret this exceeds the power as the non-arbitrability is a kind of exceedance of power. And because whenever you decide a matter that it should not be, or the parties have not agreed to submit to arbitration, you are also exceeding your power. The same thing with public policy, because you cannot decide against public policy. Also, you can it's also interpreted that the arbitrator, when doing that, is exceeding its power. It's understood from courts that invalidity of the arbitration agreement can also be interpreted as an excess of authority of the arbitrator. But you can see that this fourth ground can be very extensive, but it should never be an invitation to rediscuss the merits of the dispute. There is a fifth grounds that it's not expressly listed in the Federal Arbitration Act, which is the manifest disregard of the law. The U.S. Supreme Court has affirmed that the arbitral award will also be set aside if the award was made in manifest disregard of the law. This ground can be highly criticized, first because it's not listed in the Federal Arbitration Act, because also it's too broad and can be interpreted as a decree of review of the merits. This ground, it empowers the district courts to conduct a de novo review and question the merits of the arbitration award. I don't know if you can see here, but there is a comparison between U.S. and Brazilian grounds for the annulment, and they can. I think I used this both examples just to show that, and all the questions are very similar, and they almost in all of the countries they follow the same principle and guidelines for annulment. So there are some difference in the wordings. For example, corruption, fraud, and undue means. In Brazil is unfaithfulness, extortion, and corruption. Or instead of evident partiality or corruption of the arbitrators, in Brazil it's made by an individual who could not serve as an arbitrator. And we can go further, but the idea is just that in all other countries it's just very similar, because the annulment should only be in a very specific and extreme cases. As I have mentioned before, unfortunately in Brazil, arbitration is suffering a little bit of a credibility crisis, and there has been a lot of use of annulment procedures. At first, I think that lawyers had a certain moral barrier to use this annulment lawsuits. And unfortunately, this moral barrier does not exist anymore. And at the same time, the courts are faced with annulment procedures filed by companies with a relevant political power. And we're living in Brazil, an extremely political environment. And unfortunately, the courts, in some cases, were not able to sustain its neutrality. But we should always remember that for arbitration to survive, it must have time, cost, and judicial interventions. And the lack of judicial intervention is the real essence of the advantages of arbitration. All participants that chose arbitration at some point, and that means parties, lawyers, arbitrators, arbitral institutions, must have interest in maintaining this very essence of the solution. Frivolous annulments with judicial intervention, suspending enforcement, will increase cost, time, and transfer to national court decision a power that was taken by the parties. As a litigation lawyer, and maybe as a matter of survival and not merely as a matter of a mere optimistic, I still believe that the Brazilian courts will find back a balance and an efficient system to review awards and come back to a solution, to a place where arbitration is still a valid, efficient, and important solution for the country.
Alice, thank you so much. Very interesting and thorough analysis. And it was good that you compared with Brazil. Very interesting as well. And so thank you again. For the sake of time, instead of open for general comments, I would invite the panelists to answer one question raised by our dear friend Camila Simão. She asks the following: should US common law abolish the idea of annulling awards under the idea of manifest disregard?
Well, I think that from what I, of course, the U.S. lawyers can be more thorough about it, but I understood that the doctrine is trying to put under the excess of power of the arbitrator sometimes, so that we do not have to have a ground that it's not listed in the Federal Arbitration Law, and I think if we can be as narrow as possible, I think it will benefit of course, the arbitration, but it's also an important move for the courts too.
Go ahead, George. Do you want to address our most famous or infamous tempest in a teapot?
Yeah, let's be sure we don't intrude on the talks to come. Let me just say that I would favor its non-recognition as a ground. The restatement says that it is not a ground and is better viewed as an umbrella concept to encompass all the grounds that Alicia mentioned. Secondly, it isn't in the statute, as was pointed out, so it is anomalous that it's been invented. Third, when it was so-called invented, it was not a very deliberate decision. The very existence of this thing appears to be dictum, a casual remark by the Supreme Court decades ago. And finally, the Supreme Court has given some indications that it is not entirely attached to this doctrine. As Julie will probably tell you, it's been narrowly defined, and as a result is very rarely successful.
Yeah, very briefly, as I said, this is a little bit of a tempest in a teapot, is giving the United States a very bad reputation, but it's blown out of proportions with the reality of what this doctrine does in the United States. The time that we spend talking about it is entirely disproportionate with the reality of the impact of this doctrine on the ground. Having said that, people are, of course, reacting to what it is in theory. It's a very disruptive thought or concept, which is why we're talking about it. But I do think that, properly, of course, couched in terms of jurisdiction and excessive jurisdiction, and in its extremely limited practical application, it has not caused or wreaked havoc in a way that many might think at all. It just isn't. It isn't that doctrine. So I think we're still doing okay.
Perfect. Thank you, Julie and Professor Bermann. Now, Guerrero, the floor is yours, and we are willing to hear your thoughts on the enforcement of arbitral awards under U.S. law.
Thank you, Gustavo. I must say that it's a great pleasure to be with you this afternoon here in Brazil. I'm very glad to be back to Colombia as the way as we can now, but it's very good to share this panel, to be with Julie, Professor Bermann, Professor Kabir, and Alice. It's a great pleasure with you and Anja also. So I have to say and to split my my exposition in two related sides but different sides. The first one is recognition about international awards, and then the enforcement, strictly speaking. In Brazil, we have a peculiar reality about enforcement that I would like to address with you on the proper moment. Firstly, about recognition, we have a general rule on international law, is that the harmonization about international rules, and especially how that international rules may apply in countries that has its own sovereignty and its own rules. The basis established in the world is a basis of reciprocity. Since a state decide or agree to apply or recognize an award from the other state, it's expected that this other state do the same with that awards that come from this first state. This is what the Federal Arbitration Act says, the reciprocity principle, that reciprocity basis is something presented in the law, in the US law and in the Brazilian law. For that attention about that measure, some rules, some documents were drafted worldwide, and we may mention three. The first and the most important one is the New York Convention. Secondly, we have the Panama Convention, is the Inter-American Convention on International Commercial Arbitration. Some scholars in US mention the Panama Convention as a carbon copy of the New York Convention. And here in Brazil, we have another important set of rules, and that we call the Las Leñas Protocol. It applies for the countries here in Mercosur, Brazil, Argentina, Paraguay, Uruguay, and some others like Chile. We have some agreements with other countries from South America. And it creates a fast-track system about recognition of international awards. But addressing the New York Convention, and it is the main document that we have on that scenario, we may highlight Section 1 of the New York Convention, which shows us the determination of whether a foreign award is final, conclusive, and enforceable. And that rules must be brought by the country where the judgment and the award was rendered. That's the main rule that this Section 1 of the New York Convention bring to us. This is important to define how the national court will deal with this final decision and how this approach must happen. I must quote the Kimeksan versus Velco Enters case in US that make this rule clear for interpretation in the United States. The other section that I would like to highlight from the New York Convention is the entitlement for recognition of an international award. It brought the force and the effect of a judgment of a local court in other country, render the award binding and treat it as conclusive of the issues decided therein. So all the package brought by the award will not be fully analyzed by the state court addressed to recognize that award, but some conditions, some circumstances about that award must be analyzed, and usually are analyzed by a state court. And that circumstances are brought by the Section 5 of the New York Convention. That's important to especially harmonize the standards governing the recognition and enforcement of awards. And that Section 5 allows recognition that decline recognition when the arbitration agreement was invalid. This is a claim that must be brought by the parties in order to decline that recognition. If the losing party was not properly notified of the arbitral proceedings, it is something that also refrain this award from recognition. We have a case law here in Brazil, is the case Banco de Crédito e Inversiones versus Aloe, when the Superior Court decided that there is no grounds for that claim, since the parties were fully aware about this procedure. On third stage, we may mention if the award is not related with the claim or deals with other issues than established on the arbitration agreement. If it happens, is another situation that the recognition could be declined by the destination court. The fourth situation is related if the tribunal composition was improper. If you will have some problems on the arbitrators or the appointment of arbitrators, it may create a situation to deny that recognition procedure. Additionally, if the award has been set aside or suspended by the competent authority of the country in which or under the law of which the award was made, that recognition could be also declined. Alice addressed that point, especially in order to discuss set aside of awards and that situation here in Brazil. I am a little bit optimistic about that approach. I think arbitration in Brazil come out from, is not no longer a teenager, it's an adult institute, and we face some problems and some variation about the interpretation of some principles and rules. The same happens, I think, here in Brazil with the competence-competence. It used to be an absolute institute, and now we go to the same place or a closer place where the US is. That's a situation that Brazil is improving its doctrine about arbitration since before 1996, the year of our Arbitration Act. We don't have a tradition, especially on domestic and commercial arbitration in our country. So the other situation that may the arbitrations the arbitrations award not recognize it is related if the subject matter or the dispute is not capable to settlement by arbitration under that country's law. If the arbitrability is not clear or is not allowed by the court where this recognition is attempted, that award should be object to denial by recognition. And last but not least, if the award enforced would be contrary to the public policy. Public policies are a hot topic when parties discuss the enforcement and especially the recognition of awards. Since it's not a clear concept and it is a concept that varies worldwide. It depends on the place, it depends on the time that we are discussing. Public policy may change. Another case that I can mention and can quote is the Europacar Italia SPA versus Maranello Tours Inc. It's a case in US where this issue was raised, but that claim was dismissed by the federal court here in US. I have to say that the New York Convention, it's a convention drafted in 1958. US considering the New York Convention as a law in the 70s, and the federal courts are the courts that may analyze the recognition claims presented by the parties. The Chapter 2 of the New York Convention refers, the Chapter 2 of the Federal Arbitration Act refers to the New York Convention. We have a parallelism on the provisions of that two rules. And it's important to mention also to enforce awards in the US, the Uniform Foreign Money Judgments Recognition Act. It's a document important when we have a case about that situation. In Brazil, I said that the New York Convention was drafted in 1958. It was the year of our first World Soccer Cup, and it began law in Brazil on 2002. Is the year of our last World Champion Soccer Cup. So during that period, Panama Convention make this role about the set of rules about recognition foreign awards here in Brazil, especially for inter-American countries. But on that period, Brazil was a very closed place for business in the world, and we don't have many cases regarding arbitration to be recognized by our courts. When we have the new Arbitration Act, what the congressman did is to take some provisions of the New York Convention and put it on the Brazilian Arbitration Act. The second part of the Brazilian Arbitration Act was related to recognition of international awards. On 2002, 6 years after our Federal Arbitration Act, we have the recognition and of the New York Convention here in Brazil. Just to close this issue about recognition of international awards, I have mentioned on the beginning that the Protocol of Las Leñas creates a fast-track procedure about recognition of international awards, and that's true. We have a procedure as a rogatory letter here in Brazil. It's more an administrative procedure than a court-based procedure. So it makes this recognition faster than the other systems that we have, firstly the New York Convention and then the Panama Convention. And starting my second issue to be addressed today, we talk about the enforcement, strictly speaking, about awards. In the world, we have basically two pathways to follow when we discuss enforcement. One with more clerks and less judges. Here in Brazil, we are in the opposite. Our enforcement is completely based on the courts. What makes our enforcement procedures longer than the arbitrations that we have. So we come to a crazy situation that we spent 2 or 3 years for or in an arbitration, and then more 2, 3, 4, 5 years to enforce that award. It's something crazy. We have many theories, we have many books about it, and now we may start to make the situation easier and clear. When we discuss specific performance, it's a way to see and analyze enforcement from a procedural perspective. This comes from the traditional rule of the sale of the land. It's subject to particular laws of the states here in US, in which the enforcement is being thought. Is that what the federal rules of civil procedure from US provides from Section 70? It's more a procedure from law clerks or marshals or even sheriffs from state laws than from judges, than from the courts. In the US, we have a complete system of contempt of court. We have it also in Brazil, but the judges here in Brazil don't like to apply this system to every single case. It's difficult to have this application in Brazil. We, as I said, we follow a court-based system of enforcement. It comes from the continental Europe, and even the continental Europe, especially Italy and Portugal, that influence our civil procedure, started to change that situation and adopt the agents of enforcement doctrine, I may say. We have, and that's the hope word that we may share with you. We have a draft bill to put our enforcement here in Brazil outside the courts, to start a procedure before the Brazilian notaries. We have a huge structure and public structure of notaries here in Brazil, and they would be able to make this rule of agents of enforcement or agents of executors, officers of the court, and something like that. In conclusion, and as I have heard and listening this morning, afternoon here in Brazil, I believe that we are coming to a closer system, and a system that would be able to harmonize the needs from international trade and make that scenario and the scenario of dispute resolution and commercial dispute resolution more amicable to the companies and to the lawyers, and make it more effective. That situation about the time that we spent discussing the enforcement had bad consequences, especially for a developing country like in Brazil. Our credit become more expensive, and people have less opportunities to have money and develop our investments and develop our activities. That's what I would like to share with you this morning. And once again, I thank you a lot, and hope I will be able to help a little bit about that fantastic discussion. Thank you.
Thank you so much. Thank you so much, Luis, for guiding us through the intricacies of recognition and enforcement of arbitral awards in Brazil. As you said, not a teenager anymore, but a grown-up. In the interest of time, if you all agree, I would directly jump to our last speaker today. Is this okay for you? Perfect. So we will now move to investment arbitration and have a look on that. And with this, I pass on to Professor Duggal.
Thank you so much. Delighted to be here. I would obviously be much happier if we were all in Brazil right now, but we will make do being in New York. Let me just make two very quick comments in and out. First, to our students, bravo on doing such a fantastic event. We really appreciate your leadership. You know, we need to have further dialogues across jurisdictions. To all our, this is my second point now, to all our fabulous speakers, thank you for joining. Afternoon in Brazil, it's still morning, approaching lunch here. Thank you for joining. I also give a special mention to our students. You know, you see superstars in front of you. Try to replicate their careers, no pressure. Julie, you have set the bar very high for LLMs at Columbia forever. So students, you have the gold standard in front of you. Yeah. I'm going to talk about investment arbitration. This is a topic Professor Bermann and I teach at Columbia. It's going to be slightly different from the topic we have just discussed. You know, we had looked at commercial arbitration. This is, I think, slightly different, but in the Brazilian context, very interesting. Because Brazilians have done things the Brazilian way. There's always a unique angle to things. And this topic brings out the Brazilian approach very interestingly. Let me just start off, and I'm going to insult the intelligence, but this is still a new concept in Brazil. So very high level discussion, again, focusing on Brazilians here. What would happen if you were a foreign investor going to another country and the state in that foreign country, capital S state, did actions that you didn't like, right? So if you were the Austrian, Anya, in honor of you, if you were the Austrian investor going to Brazil, what were the traditional options you had? Well, the options you would have traditionally would be go to Brazilian courts. But, you know, if you are challenging the actions of Brazil, going to Brazilian courts, right, kind of seems awkward and strange. But that's one option that does exist. The second option that you had is Anya goes to Austria and tells Austria, why don't you take my case and fight it out with Brazil? This is diplomatic protection. Now here, just note what is happening. Austria, the country, is raising a dispute against Brazil in its name. So it's a state-to-state dispute resolution mechanism. And finally, this should be something familiar to all of us, right? If you have a dispute and your contract provides for commercial arbitration, you have commercial arbitration, right? That's what we have been talking about. We were looking at the challenges in enforcement, but these would be your three traditional mechanisms. All of these have some limitations, right? And that's what gave rise to investor-state arbitration. Now, what is investor-state arbitration doing? It is allowing a foreign investor, in our case, Anya, to bring an action against a state, a country, directly. So Anya brings the arbitration directly. You did this predominantly through treaties. They were bilateral, multilateral treaties. And you got arbitration through an organ of the World Bank. This is ICSID, or ad hoc arbitration through UNCITRAL. Now I'm going to simplify things in the interest of time, but this is a very prevalent mechanism to resolve investment disputes, right? You didn't go through commercial arbitration. You had investor-state, the specialized form. Investor-state arbitration today is under very heavy criticism. People criticize the fact that you're allowing tribunals to look and make policy decisions. You're criticizing the standards in treaties, right? It is arbitration. So you don't have a jurisprudence. So different tribunals are doing different things, and this is creating a lot of confusion. Now, I present this just to show what Brazil is thinking, because it is fascinating. Brazil, this should be obvious to all of us. It's a ginormous country. It's almost a continent, right? I have this very funny map where entire Europe is placed within Brazil. It's not a region we can ignore, okay? Now, Brazil is very significant because Brazil was Exhibit A to the fact you didn't need treaties, right? Brazil refused to sign investment treaties, and Brazil has, well, this shouldn't surprise anybody, still been one of the largest recipients of foreign investment, right? So you look at Brazil and say, hey, are these treaties really worth it? Now, I just do note here, every country is not Brazil, right? Brazil is this continent country. But we take that criticism for what it is worth, and I just put that out there. Brazil today, and by today I mean from the past 4 or 5 years, has rethought its policy on how we should think of investment arbitration. And they have come up with a unique model, and a model that we should think about when we're thinking about the reform in light of the backlash. The Brazilian approach is not investor-state arbitration. The Brazilian approach says, investor, if you have a dispute, the countries will have national focal points. You, investor, go to the national focal point, and the national focal points of both countries will get together and consult to resolve the dispute. If that fails, we're not going to have investor-state arbitration. We're going to have state-to-state arbitration. I think if we think about the evolution, it's sort of becoming full circle. Initially, Anya had to go to Austria and have Austria raise the dispute with Brazil. Then we had come to a regime that allowed Anya to bring a dispute in her own name, Anya against Brazil. Today, Brazil is offering us a new model, a different model, where we're going back to potentially where we started. Let's have state-to-state arbitration. The important point here is traditionally the money didn't go to the investor. When Austria got the money, Austria could keep it, or if Austria liked Anya, they gave it to her. Brazil makes clear no. When there is state-to-state arbitration, we will make sure Anya gets the money. So that is an improvement. But the Brazilian approach is significant because we are seeing a lot of countries getting attracted to this model. I give the example of my own home country, India. India had decided to rethink its policy. It came up with a new model, BIT, and said, we're not going to sign a treaty with any country that doesn't follow the Indian approach. This year, Brazil and India signed a treaty, and guess what? India is adopting the Brazilian approach. So much for the Indian national pride, we put that aside. But India does see merit in what Brazil is proposing. They do think this is a good model. I'm going to end here, and I think we're almost at time, but I'm going to end here because we now have a new model that we should pay attention to as we're rethinking global policy on foreign investment. I'm going to stop here and pass it back in the interest of time, but folks, take it away.
Thank you so much. Thank you. I hope I will never come into position to sue Brazil. We have one more question from the audience, actually, to your speech, Luis. so coming back to the enforcement, so Louis Tamburini asks how U.S. courts reconcile the constitutional requirements on personal jurisdiction with the New York Convention, exclusive grounds for denying enforcement.
That's a that's a question that we can make a seminar to discuss the. But I think that situation is commonly or ordinarily faced by the judge, especially to have the Constitution at the same, not the same stage, but as the basis for all the interpretation that they must do, analyzing the international conventions. And I may say, especially from a Brazilian perspective, and I don't think in US it would be quite different. State countries would like to protect their constitutions and the interpretation of their constitutions. In case we have something that is not in compliance with the constitution coming from abroad, the consequence would be the refusal of that recognition. So I think that the answer for me would be in that way.
Anyone else?
Yep. Yes.
Professor Bermann, please.
Very briefly, because we're over time. If I understood the question correctly, it was how requirements of personal jurisdiction would impact the efficacy of the New York Convention. And that's obviously a very important question because the New York Convention is aspiring to universal or nearly universal recognition and enforcement of awards, and personal jurisdiction of national courts can be highly restrictive. And in the United States, you ordinarily require either residence or domicile or doing business or having some other nexus. And if that were required, New York Convention would be negatively impacted, as my own class will hear tomorrow in our class. We've solved that problem largely by saying personal jurisdiction requirements are in place in actions to impose liability, but if the action is only to enforce a judgment or an award but not impose liability, then the personal jurisdiction requirements are not applicable. So a very powerful distinction between litigation to impose a liability, which is what we usually think of, where personal jurisdiction must be satisfied, and suits to merely enforce an award or a judgment, then personal jurisdiction ceases to be an obstacle. That's very important for purposes of the New York Convention. Any state that imposes strict personal jurisdiction requirements on enforcement actions obviously limits the efficacy of the New York Convention. So that's it in a word, Anja.
Thank you so much. Are there also any questions to Professor Duggal's speech? Any comments? Because then I would wrap up. Thank you all so much for taking the time in your busy schedule. Really appreciate it. It was lovely having you all here and such an interesting talk. Yeah, so hope to see you all soon.
Thank you so much. Thank you so much. Sorry we had to rush things a little bit. It was for the sake of time, but thank you so much for being here with us. See you. Okay. Bye-bye.
Thank you.
Bye.
Bye.
Bye.